President rejects Tamil Nadu's request to release Rajiv Gandhi assassination convicts, part of GS prelims and mains. Indian polity in news. President Ram Nath Kovind rejects Tamil Nadu government's request to release the 7 prisoners convicted for the assassination of former Prime Minister Rajiv Gandhi. In the last 4 years, Tamil Nadu government has written twice to the Home Ministry to pardon the convicts and release them on humanitarian grounds. President has rejected the request on the advice of the Home Ministry. The President is bound by the advice of his Council of Ministers in such matters. Do you know? Article 72 deals with power of President to grant pardons, etc., and to suspend, remit or commute sentences in certain cases. Article 161 deals with power of Governor to grant pardons, etc., and to suspend, remit or commute sentences in certain cases. President can grant pardon, reprieve, respite and remission of punishment, or suspend, remit or commute the sentence of any person convicted of any offense, by in all cases where the punishment or sentence is by the court-martial, in all cases where the punishment or sentence is for an offense against a union law, and in all cases where the sentence is a sentence of death. The pardoning power of the President is independent of the judiciary. It is an executive power. Does India need office of governor? About the state governors of India, the product of a time long past, have been under the scrutiny of the public eye for a long time now, especially after the high drama which happened after recent Karnataka elections. Yet, despite their notorious reputations, little seems to have been done. Some of the actions taken by the governor were part of uncertain gray area of discretion, partisan enough to skew the process in favor of the BJP, but not illegal enough to warrant judicial intervention. In the aftermath, some have called upon the governor to resign, others have suggested that the post of the governor be reserved for non-political appointees, and some question the need for office of governor, and still others have urged the Supreme Court to lay down the law on how the governor ought to act when an election yields a fractured verdict. The below article is excerpt from the Hindu editorials which analyzes and answers some of these questions. Office of Governor during colonial era and pre-independent India. It is important to understand the origins of the office in the colonial British regime. Through the course of the early 20th century, the Indian nationalist movement managed to extract gradual and incremental reforms towards responsible government from the British rulers. These reforms culminated in the Government of India Act, 1935, which established provincial legislative assemblies elected from a limited franchise. However, in order to ensure that overriding power remained with the British, the Act retained the post of governor, a holdover from the old diarchy system, and vested him with special responsibilities that, in essence, allowed for intervention that will K.T. Shaw, one of the most articulate members of the Constituent Assembly, or CA, wrote that the governor would inevitably be biased in his functioning, and his actions would remain at odds with those of popularly elected ministers. Despite the nationalist movement's bitter experience with governors over almost 3 decades, the CA chose to retain the post, and continue to vest it with discretionary power. During CA debates, it was pointed out that the articles dealing with the powers of the governor were almost verbatim reproductions of the Government of India 1935 Act. Defenders of the office raised 2 broad arguments. First, that there was a dearth of competent legislators in the states, and second, that a certain amount of centralization of power was necessary in a nascent state such as India. They felt that there is need for office of governor who would stand as a bulwark against secessionism and to act as a check upon both federalism and popular democracy. Concerned members of the CA were assured that the governor would remain only a constitutional post, and would have no power to interfere in the day-to-day administration of the state. But, even though the framers insisted that it was only a constitutional post, Karnataka has just been the most recent example demonstrating that the governor has enough discretion to skew the political process in the direction that the central government desires. Now the question arises whether the above arguments of CA serve any valid purpose in 2018, and if not, whether it should continue to exist. Is there a need for clearly specifying the rules governing government formation in the Constitution itself? Misuse of office and flaw in appointment process. There are numerous examples of the governor's position being abused, usually at the behest of the ruling party at its center. The root lies in the process of appointment itself. The post has been reduced to becoming a retirement package for politicians for being politically faithful to the government of the day. Consequently, a candidate wedded to a political ideology could find it difficult to adjust to the requirements of a constitutionally mandated neutral seat. This could result in bias, as appears to have happened in Karnataka. The governor has the task of inviting the leader of the largest party/alliance, post-election, to form the government, overseeing the dismissal of the government in case of a breakdown of the constitution in the state, and, through his report, recommending the imposition of president's rule. There are examples of the last two having been frequently misused to dismiss the belligerent state government, but this has been checked substantially by the Supreme Court through S.R. Bommai v. Union of India. Since the Bommai verdict allows the Supreme Court to investigate claims of malafide in the governor's report, a similar extension to cover malafide in the invitation process could be a potential solution. Why the office of governor is important. Governor, an important overseer under the constitutional scheme, the governor's mandate is substantial. From being tasked with overseeing government formation, to reporting on the breakdown of constitutional machinery in a state, to maintaining the chain of command between the center and the state, he can also reserve his assent to bills passed by the state legislature and promulgate ordinances if the need arises. Further, under Article 355, the governor, being the central authority in a state, acts as an overseer in this regard. Governor, an important link in India. The balance in power is tilted towards the union. Governor acts as a crucial link within this federal structure in maintaining effective communication between the center and the state. He is also a mentor and a guide to the state governments, as a figurehead who ensures the continuance of governance in the state, even in times of constitutional crises. His role is often that of a neutral arbiter in disputes settled informally within the various strata of government, and as the conscience keeper of the community. Therefore, the institution of governor has a pivotal role to play within the federal structure and constitutional framework of our country. Misuse of a position of power should not serve as a justification for removing the office altogether, unless such a position has totally lost its relevance. Connecting the dots. Governor has a constitutional obligation to preserve, protect and defend the Constitution. They must not only be fair but also be seen to be fair. Elucidate. What are the functions of the governor with regard to protecting and promoting the interests of the state concerned? Do you think governors are acting as if they are the employees of the central government? Examine. Controversy over Article 35A part of GS Prelims and Mains II, Indian Polity, Indian Constitution. In use, Article 35A is often in use. The article, which was unknown to the public domain till recent times, has raked up an intense debate in the country when a Kashmiri woman, Chiruway Khan, filed a petition to change the constitutional provision as she wanted succession rights in the state, though she is settled outside the state. An NGO, We the Citizens, had also filed a petition to strike down Article 35A. The NDA government wants to have a larger debate over the Article 35A challenging the constitutional validity of the clause. What is Article 35A? Article 35A of the Indian Constitution is an article that empowers the Jammu and Kashmir State's legislature to define permanent residents of the state and confer on them special rights and privileges in public sector jobs, acquisition of property in the state, scholarships and other public aid and welfare. The provision mandates that no act of the legislature coming under it can be challenged for violating the Constitution or any other law of the land. It was added to the Constitution through the Presidential Order of 1954 with the then J&K government's concurrence. Article 35A does not allow people from outside the state of Jammu and Kashmir to work, settle their own property in the state. For time being, let us remember only this. Analysis part will be delved in future once we come across any editorials or opus secularism in India about. The below article tries to answer how did the idea of secularism take root in India. Background: during colonial rule in India, England was not a secular country and there was no wall of separation between church and state. The Act of Supremacy enacted in 1534 declared that the monarch was the supreme head of the Church of England. The archbishops and other high-level church officials were appointed by the government. New monarchs were crowned by a senior member of the clergy, and senior bishops were represented in the House of Lords. Much of this remains true today. Even in British India, initially East India Company, the IC got itself intricately entangled with the administration of religious institutions. Temple employees were appointed by government officials. Royal salutes were fired from the batteries of 4th Street, George in Madras, at the celebration of Pongal, and at Rampan. Under the orders of a public officer of the district, a religious offering was made at temples for a good monsoon. Laws were enacted which said that the general superintendence of all lands granted for the support of mosques and plus Hindu temples was vested in the colonial government. However, all this annoyed Christian missionaries and members of the clergy in England and India who put pressure on the government. Religious Endowments Act of 1833. Consequently, in 1833, the Court of Directors of the EIC sent instructions to the colonial government outlining its policy towards India's religions. Religious Endowments Act. All religious rights that were harmless were tolerated, however false the creed by which they are sanctioned. The interference of British functionaries in the interior management of native temples, in the customs, habits and religious proceedings of their priests and attendants, in the arrangement of their ceremonies, rites and festivals, and generally in the conduct of their interior economy, were seized. It was in this manner that the seeds of secularism were sown in India. In other words, the colonial government was directed to disentangle itself from superstitious Indian religious institutions, because Indian religions were considered heathen and false. However, the Church of England in India was still established for a long time. Therefore, the wall of separation between temple and colonial state in India was achieved in 1863 Religious Endowments Act. With this law, the colonial government got rid of its burden. However, this colonial vision of secularism was rejected by India's founding fathers. Vision of India's founding fathers. After the Government of India Act, 1919, Indian legislators came to power at the provinces. Indian political leaders enacted the far-reaching Madras Hindu Religious Endowments Act, 1926, which virtually took over the management and administration of Hindu temples in the province. It established boards appointed by the government. Temple trustees had to furnish accounts to and obey the instructions of the boards. Temples' surplus funds could be spent by the boards themselves on any religious, educational or charitable purposes not inconsistent with their plus objects. Constitutional framers were inspired by the U.S. Constitution provision which prohibits Congress from making any law respecting an establishment of religion. In the Constituent Assembly, P.R. Ambedkar drafted an establishment clause which said that *T+C state shall not recognize any religion as state religion. K.T. Shaw draft said that the government would be entirely a secular institution which would maintain no official religion or plus established church. However, these clauses didn't find their way into the Constitution. If it had, then the Madras Hindu Religious Endowments Act, 1926, could possibly have been found unconstitutional. Later, H.V. Commons tried to move an amendment in the Constituent Assembly to introduce an establishment clause. The state shall not establish, endow, or patronize any particular religion. However, his amendment was put to vote and rejected. Current scenario: the Supreme Court has allowed governments to heavily regulate Hindu temples on the theory that the freedom of religion does not include secular matters of administration which are not essential to the religion. Sometimes, the court has perhaps gone a little too far, since the line between integral religious practice and non-essential secular activity is often hard to draw. For instance, though the government cannot interfere with rituals and prayers at temples, it can regulate the amount that temples spend on such things. Even the appointment of priests in Hindu temples has been held to be a secular activity, which the government can regulate. Conclusion: in a letter written in 1802, President Thomas Jefferson advanced the idea of a wall of eternal separation between church and state in the U.S. The wall of separation between temple and state in India was first constructed by a colonial government which wanted to distance itself from religions that it considered heathen and false. That wall was then pulled down by Indian leaders who felt that government entanglement in religious institutions, especially Hindu temples, was essential, even in a secular state. Connecting the dots. Give your views on the right to freedom of religion as enshrined in the Indian Constitution. Do they make India a secular state? What is secularism? Also discuss how did the idea of secularism take root in India.